Hello, good evening, everyone. A warm welcome to you all, and thank you for joining us today. We truly appreciate your presence. This session is part of our Pro Studies Copy series, and today we are conducting our fifth session, specially organized for students preparing for the April exam, first year exam. Before we begin, I kindly encourage everyone to stay engaged, take notes, and make the most of this session as it is designed to help you study more efficiently and perform confidently in your exams. I'm ONARA Vijayasinghe and I'll be your moderator for today. Please feel free to share your questions in the chat. And let's keep this session interactive and worthwhile. Before moving forward, I would like to extend my sincere gratitude to Pro Studies for organizing this valuable Kuppy series and for continuously supporting students in their academic journey. To guide us through this session, we are honored to have a special guest with us today. He is an intermediate year student at Sri Lanka Law College and who performed exceptionally well in preliminary year exam last year, securing a high mark for legal drafting and statutory interpretation. And he is also an LL.B undergraduate from General Sir John Kotelawala Defence University. And having gone through the same journey you are facing now, he is well practiced to share these valuable insights and strategies to help you succeed. So, without further delay, it is my great pleasure to welcome Mr. Sanka Ranawake. We are truly honored to have you with us today, and thank you for taking your time to guide and support us. And I now hand over the session to you, Mr. Sanka.
Hello, Nara. Am I audible to you?
Hello.
Am I audible to you all?
Yes, you are.
Yeah. So first of all, I have to apologize for the delay. There was an unfortunate technical difficulty from my side. So thank you for your patience. And without any further delay, we'll move on to the session. So first of all, I hope you all most of the participants who are in the meeting now are, are focusing on the April examination. So most of the students who are facing for the April examination, they have some sort of an experience in uh, if they have written or faced in the October examination, or if even not, they have some sort of an idea about the subject because they have participated into the lectures as well. So I'll do this session uh, with that thing keeping in my mind because I'm telling this thing and I'm doing this session for you all, thinking that you all have some sort of an idea about statutory interpretation. Don't worry if you don't have any idea about it. I'll explain it in a quite easy and easy to understand manner. So if there is any issue, if there is any concern about the subject or any other thing, please feel free to interrupt me then and there and ask any question from myself. So, and another thing, I have to tell you that I am not a good tutor. So I may make some errors in my language and some stuff, but apologize me for that. And give and I may not know that when you understand the stuff or not. So if you didn't understand anything, please feel free to tell me then and there, then I'll explain it to you again. So thirdly, I'll mainly do this subject in English language, but when I feel it is necessary to do it in Sinhala as well, I'll repeat the stuff and explain it in Sinhala as well. And if you need anything to be explained in Sinhala, I'll do it in Sinhala as well. So it, we are doing an interactive session here, as Onara mentioned. So basically, I want you to interact with me and ask questions and milk out the knowledge I have in my mind. So let's, without any further explanations and disclaimers, let's move on to the session. So before discussing about theories of interpretation, we have to know what is statutory interpretation. So when we look at the legal, so you all are preliminary year students, as I know. So when we are referring to interpretations, sorry, definitions and meanings about any legal word, we have to get the legal meaning of that. So if we go with the legal meaning of the statutory interpretation, it is the process by which courts interpret and apply legislation, resolving ambiguities in written laws using recognized principles, canons of construction, and legislative intent. I'll repeat. Statutory interpretation is the process by which courts interpret and apply legislation, resolving ambiguities in written laws using recognized principles. So that is the legal meaning of the statutory interpretation. So at the very first moment I have read that and studied for my October examination, I really didn't understand what is statutory interpretation is. And I thought this is not a good subject to study, and it is not a what we have to study. This is not a good subject like criminal law, contract law, what other subjects we are doing in preliminary year, which is a basic subject. And I thought that this my attention should not be focused on this. But when I come to the intermediate, when we are doing in administrative law, I understood the importance of this subject. So with that perspective, I'm telling you, learning this subject is extremely important for you. This is not applying to the law, legal practice directly, but in an indirect method, we are using this in everyday life. I had the notion when I'm doing this subject, uh, I'm not going to be a judge any day in, if in future. So I thought there's no point in studying this subject. But when I'm doing admin law and other subjects in second year, I understood that this subject is the core subject behind most of the subject we are doing in the intermediate year. So listen carefully and try to understand and try to grab everything what I'm saying in this session. So today we are going to look at one of the most important areas in laws, which are the theories of statutory interpretation. So as I mentioned before, you need to understand one core idea. So I have given you the legal definition. So now I'm going to tell you the main function of the statutory interpretation. It will help you to understand the subject. The main function of the statutory interpretation is to give effect to the intention of the parliament. So when we look at statute, let's take any statute we know. Uh, the, those statutes are filled with so many sections, subsections, and all those stuff. But when we are going for a court case, uh, there are many black letter words in that, and we don't know the exact meaning or the uh, exact intention of the parliament. So in statutory interpretation, what court is doing is reading in between the lines of those sections and identifying what is the intention of the parliament. So basically, through statutory interpretation, court is doing that part which is finding the intention of the parliament, which is sometimes hidden in the statutes. So as I mentioned before, Parliament writes laws in words, and as we all know, words are never perfect. When you are also talking to your friends and colleagues, So you are also using so many words that even filler words and all those stuff. So when you're speaking with them like that, uh, they might sometimes did not understand the exact meaning of what you are saying. So they might ask you from several times what මොකද්ද මසන් කිව්වේ like that. So this is the so the, this is the same process the court is doing to understand the intention of the parliament. So, so interpretation is needed because interpretation is necessary because laws are not always clear. As I mentioned before, ඔගොල්ලොත් කතා කරනකොට වගේ අපි කතා කරද්දි සමහරලාට කියනවා අපි කොහෙද අර අපි යන්නේ කොහෙද මල්ලේ පොල් වගේ තියෙන. ඒ වගේ වෙලාවටදී අපි කතා කරන දේ නෙමෙයි අපි අපේ ඉන්ටෙන්ෂන් එක වෙන්න පුළුවන්. එතකොට ඒ වගේ අවස්ථාවලදී ලෝ එකේ ලියලා තියෙන හැමදේම ලියලා තිබ්බට ඒක වචන වලින් තිබ්බට ඉන්ටෙන්ෂන් එක ගන්න එක අමාරු වෙන්න පුළුවන්. ඒ නිසා ඒ ඉන්ටෙන්ෂන් එක ගන්න එක තමයි ස්ටැටියුටරි ඉන්ටර්ප්‍රිටේෂන් එකෙන් උසාවිය කරන්නේ. එතකොට mainly the words in the statutes are not clear due to certain reasons. There are 5 of them. Number 1 is broad terms. Sometimes, let's take an example. There's a term in a section of the statute which is referred to as animals. So if it is written in such a manner, word animal can give different ideas. Domestic animals, wild animals, pets, and it can mean anything. So it's a broad term, it has a broad meaning. So in that occasion, court has to look whether the what is the parliament's intention is, and whether they are referring to wild animals, whether they are referring to pets, or whether they are referring to domestic animals, or whether they are referring to all of them. So that is what doing by statutory interpretation in broad terms. Another reason is change of use of language. So we are in the 21st century now. So the words, most of the statutes and the legal draft things we are using in the modern system as well are established and written in 20th century or even before that. So most of them are ordinances we are using. So like even in the Gen Z, they are using very different language to the previous generations. So what they have used, the language they have used can be different from today. So that is also a reason for you to use statutory interpretation. And there might be sometimes some drafting errors because even though Parliament look into those matters and statutes several times and gone through several procedures, there might be several errors, drafting errors, which should be answered. So through statutory interpretation, that is also reduced, and their court is interpreting those drafting errors as well. And there are some ambiguous terms, as I mentioned before as well. Some ambiguous terms like it can give some different the same word can give different meanings, so several meanings. As I mentioned before, the word animal. So that is also a reason for this statutory interpretation. And finally, new developments of the law. New developments of the law means with the development of the society and of the technology, new words are coming to the language in every day, almost in every day. So without the new trends and tendencies in the society, law also needs to be evolved. So with those developments in the legal sector, sometimes statutory interpretation is important uh, due to that, because as I mentioned, most of the laws we are already using in Sri Lanka also were made in 1800s and 1900s. So with the modern technological advancements and with the societal developments, those words may not exactly give the meaning of the today. So it's court's responsibility to examine that and give a specific interpretation to those terms according to the new developments of the law. Am I clear? Am I clear to you up to that? Up to that? Okay, I think I'm
Yes,
clear to
I
you.
think so.
Yeah, thank you very much for your response. And yeah, I'll give you a case law now. So basically, when you are writing an answer, uh, I'm basically referring to case laws and what scholars have mentioned because it is giving some sort of an idea to the examiner that you have read and gone through those stuff and you have the specific knowledge. So we are writing this answer under 30 minutes. So we have to write extremely fast and in a specific manner. So this is writing case laws and scholar name of the scholars and their definitions about legal factors uh, give an impression to the examiner that you know about the stuff, and due to the time concerns, you have not written it in the whole manner, but you have know the law and then know the case facts as well. So I I think from my perspective, writing case laws and scholarly definitions is important in your answer because for that good impression. So first, I'll give you the Ghulam Muhammad Lali versus Imtiaz Ahmad Lali case. In that case, court held that no word in the statutes is to be rendered meaningless or so it is court's responsibility to give full effect to the words of the legislation. So basically, what it means is that we can't as the court they cannot accept any words in the statutes that these words are meaningless. Making එච්චර වැඩක් වෙන්නේ නැහැ. මේක මේ statute එකේ නිකන් තියෙන දෙයක්. එහෙම කියලා කිසිම කෑල්ලක් අතාරින්න බෑ. ඒක legislation එකේ තියෙන හැම මේකක්ම එහෙම නැත්නම් පනතේ තියෙන හැම විධිවිධානයක්ම හැම විධිවිධානයකම තියෙන වචනයක් සැලකිලිමත්ව බලන්න ඕනේ මොකද්ද පාර්ලිමේන්ත එකේ ඉන්ටෙන්ෂන් එක කියලා හොයාගන්න. ඒ නිසා මේ ඇක්ට් එක තියෙන හැම වචනයකම වැදගත්කමක් තියෙනවා. ඒක තමයි ගුලාම් මුහම්මද් ලාලි versus ඉමිතියාස් අබ්දුල් ලාලි කේස් එකේදී කියන්නේ. Then we'll move on to the functions of statutory interpretation. As I mentioned before, the main function is to give effect to the intention of the parliament. And so I'll discuss it further. Historically, the literal interpretation dominated the rules related to statutory interpretation. We'll discuss the literal interpretation later in this session. This approach is clearly seen in Great Britain from the time it transformed from the monarchy to parliamentary system of government in the 17th century. The words of the statute give the intention of the parliament that therefore the intention of the parliament should be deduced only from the words and not from any extrinsic material. However, new rules play an important role in modern systems, hence statutory interpretation has become an evolving subject in all legal systems. The purposive approach to the statutory interpretation, which we are going to discuss further in the session, is the ultimate legal rule in the statutory interpretation. It provides a holistic approach to ascertain the intention of the parliament. The function of statutory interpretation has become a more dynamic in regard to interpretation of the Constitution. In this context, the Constitution has been treated as a living document and adapted by court to meet the challenges of a changing world. So, statutory interpretation firstly started as a from the literal interpretation, and it has developed and moved on to dynamic interpretation as well, which identifies the Constitution and the other significant statutes as living documents. So you can clearly see the development of the sector in the statutory interpretation. So the function of statutory interpretation become complicated when a statute deals with treaties and non-treaty instruments when the enactment of implementing legislations. Therefore, the courts in many countries have overlooked the provisions of the statutes and have given effect to norms and standards enshrined in the treaty or non-treaty instrument. So this is the basic stuff you have to understand about the statutory before getting some sort of an understanding about the theories of statutory interpretation. And those are the basic stuff you have to know about what is statutory interpretation and what are the functions of it. So without wasting any time, we'll move on to the rules of statutory interpretation. So uh, there are two types of rules in statutory interpretation. Number one is traditional rules, and number two are the modern rules. When we look at the traditional rules, we can identify three traditional rules, which is literal rule, as I mentioned before, the golden rule, and the mischief rule. So the selection of correct approach listed above in the given factual context is of fundamental importance to ascertain and give effect to the intention of the parliament. So it is up to court to decide whether they are going to use the literal rule or the mischief rule or the golden rule, depending on how to ascertain or how to entertain the intention of the parliament. So in the common law and civil law countries, the application of these rules can be different. In common law countries, a literal approach is generally taken to interpret and apply statutes. As I mentioned before in the introductory part, uh, many common law countries, including UK and Sri Lanka, we have some sort of a tendency to choose the literal interpretation or use give the meaning to the exact word mentioned in the statute. But in civil law countries, there's a teleological approach or a purposive approach is taken to interpret and apply statutes. They are looking into this, they are reading in between the lines of the statutes and try to identify the intention of the parliament. So keeping that in mind, we'll move on to the first traditional rule, which is literal rule. So literal rule states if the words of the statute are clear, it is mandatory for courts to give effect to them, whether the result leads to whether even it leads to unreasonableness. So it is some sort of controversial thing. So it tells court has to give the exact meaning of the word, the ordinary, the grammatical meaning, or the dictionary meaning. So let's take the word. Let's take the word public health. So they have to give the meaning of that word according to the dictionary. So what is given in the dictionary? So they are not looking into the what is the intention of the parliament or what they have tried to impose on the society. What they wanted to be done. They are not going to look into that thing. They are only focusing of the dictionary meaning of the thing. That it is what the literal meaning means, as it very simply means as the word literally suggests, it is the ordinary, natural, and grammatical meaning or the dictionary meaning. So in the later part of the explanation, I mentioned that even if it creates unreasonableness, they have to apply that. So it says that sometimes application of the dictionary meaning can create some unreasonableness in the society. But even though that meaning is available, dictionary meaning is available, they have to stick to that. Even some part of the society or the party in the case, even they get unreasonable experiences or unreasonable outcomes through that. Even in that case, they have to use the literal rule, or you have to use the literal meaning of that word or of the term. So if the statute is clear, they have to apply that part, even it may conclude some unreasonable results. So this is bit controversial, as I mentioned before, and remember that this is a extremely old rule that we are talking about, because it's a traditional rule and it's the first rule I think that the interpreters have used. So with the time and the rules are evolved, and now they are in a very drastic manner than literal rule. So anyway, this is where it started. So uh, in the case decided in UK, R versus Judge of the City of London, Lord Esher says that if the words of the act are clear, you must follow them, even though they lead to manifest absurdity. So if you are getting notes, please write down this case, because this is extremely important, and this explains the literal rule in a really fine manner. So case name is R versus Judge of the City of London Court. In that case, Lord Esher, ESHER, said that if the words of an act are clear, you must follow them even though they lead to and manifest absurdity. That is what I discussed before. So the court has nothing to do with the question whether the legislature has committed an absurdity. So even though the legislature committed absurdity, it is not up to court to decide that. They have to apply it in the manner which is in the statute. So the literal rule is the most elementary rule. As I mentioned before, this is extremely simple and they are applying the literal meaning of the words, even without taking any concerns about whether it can manifest absurdity or not. They are applying it. So it's a extremely elementary rule in statutory interpretation, uh, as even stated by Professor Sir Rupert Cross. So it gives effect to the plain meaning of the legislative sentence. So when it comes to Sri Lankan context, it is as I mentioned before, the common law countries, they have tendency to apply the literal rule. So in Sri Lanka also, in many cases where there need to be some sort of an interpretation, they apply literal rule. So in the uh, in in the uh, Yeah, in the Somavati versus Veerasinghe, I'm just telling the most important case laws because we are at the edge of the exam, so there's no point of wasting time on all the case laws. So I'm mentioning the most important stuff. So the Somavati versus Veerasinghe case, the third party applied for a FR. So you may have known about this thing from the constitutional law as well. In the Somvati versus Veerasinghe case, uh, I'm sorry, uh, wife applied for the FR on behalf of her husband, but the Supreme Court stick to the statute and under the Article 126, subsection 2, they mentioned that only the person whose rights are affected and an attorney at law representing him can file a fundamental rights petition in the Supreme Court, and the wife does not have any right on that. So, that is a very good example where the Supreme Court applied the editorial rule and stick to the words of the Constitution and rejected the application of the wife for the breach of fundamental rights on behalf of her husband. So remember that case. It is extremely important, and I think it is. You can easily write it at the exam as well because you are studying it for the constitutional law as well. So next, in Seaford Courts at States was Asher case, the court held that a judge must not alter the material which the act is woven, but he and should iron out traces. When a defect happens, a judge cannot simply fold his hands and blame the draftsman. So it means that the words in the statutes are already published and given to the courts. It is done by the legislature. But according to the literal rule, the court cannot change the words or they change the meaning of the words in the statutes. The only thing they can do is to iron out the creases or to polish it, only to polish it. Keep that in mind like that. So they can't change it, they only can polish it. So when a dispute happens, court cannot just fold their hands and blame the draftsman that ඔයාලනේ මෙතන වැරදි අපිට කරන්න දෙයක් නැහැ. So they can't be like that. So court must give us some sort of an answer and remedy to the party who's affected. But even though under the literal rule, they can't change the meaning of or the words of a statute. So as we discussed through, and I would like to mention another case as well, the Professor Priyani Soisa versus RNC Arshakularatna case. In that case also, the Sri Lankan judge applied what is mentioned in the Seaford Court Estates versus Asher case. In that case also, he mentioned that I think, I quote from the case, I think we are not entitled as judges to change the material of RDL, material of Roman Dutch law, but only permitted to iron out the cases. So basically, you can see that we are applying directly the UK cases and how the cases, how the judges, how UK judges decided the cases, and we are using it directly to decide cases here as well. So that is the link between UK and Sri Lanka. So in here also they directly and they use as the same example here as well. So that is how literal rule applied in Sri Lanka. So in the literal rule, the use of the literal rule has merits and demerits, which are determined by legislative supremacy of parliament, rule of law, and the importance of the judicial discretion. So when we are doing this part, you may have identified some merits and demerits in the literal rule. So when it comes to merits, this rule promotes certainty in law. So if, okay, let's explain it like this. So now I'm going to the court to for asking, okay, let's take the Somati versus Veerasinghe case. So I'm going for the Supreme Court to file a fundamental rights application on behalf of my wife. And the court says that I can't do that because according to the literal rule, under Article 126, subsection 2, the Constitution directly prohibit you, it is me, from filing a fundamental rights petition on behalf of my wife. So they are telling that to me. So another person, let's think Pereira. Pereira is going to the Supreme Court as well. And he also asked for the same thing. He's also asking for the fundamental violation on behalf of his wife. So court says the same thing to him. So there's a certainty in law. So in the on the other hand, if the judges applied the law in a purposive manner, there's some sort of an uncertainty, because when it can be depend on the judge who is sitting on the bench. So if he's a good judge who identified and understood the situation of myself and identified that my wife cannot attend to the Supreme Court and represent herself in the court, he'll definitely listen to me. But sometimes a judge may not listen to me and stick to the black lettered laws in the book. So that uncertainty is there. In the literal rule, even though even myself or any other person goes there, uh, the interpretation does not depend on the judge's whims and fancies. So as a result of that, I'm getting this exact same thing, but which is given in to the another person as well. When you go to the example I have taken, Pereira and myself, both of us, we are getting the same thing. So and this rule promotes consistency. So through this certainty, it creates a consistency. After giving my judgment that I can't go for the fundamental rights application on behalf of my wife, now after myself, Pereira also wants to go. Now Pereira knows that there's no point of I applying for this because I cannot get the leave to appeal on my favor, because there's already a judgment given to Sanka that this fundamental rights application should not be allowed. So consistency is there. Each and every person, the future applicants or claimants, they also know that they cannot go for it because of that. So this rule upholds the parliamentary sovereignty and respects the theory of separation of powers. So the theory of separation powers, you may have learned it in constitutional law. So I'm not going to discuss in here. So it is parliament's role to establish laws of the country, and it is judiciary's role, it is the judiciary's role to do that in the society. or the එකනට තියෙන ක්‍රියාත්මක කරන එක. ඒ කියන්නේ legislature එක තමයි නීති හදන්නේ, judiciary එක තමයි නීති ක්‍රියාත්මක කරන්නේ. එතකොට through the literal rule, uh, judiciary respects that parliamentary sovereignty, that they are, ඒ කියන්නේ ඒගොල්ලෝ respect කරනවා parliament එකේ ability එක නීති හදන්න තියෙන. ඒගොල්ලෝ ඒකට interrupt කරන්නේ නැහැ. ඒගොල්ලෝ ඒකට එක එක interpretations දීලා වෙලා මේක වෙන්න නැති ඒගොල්ලෝ බලාපොරොත්තු වෙන්නේ නැත්තේ, මේක වෙන්න නැති ඒගොල්ලන්ට හිතෙන්නේ නැත්තේ, එහෙම කියන්නේ නැහැ ඒගොල්ලෝ. ඒගොල්ලෝ ඒගොල්ලෝ දුන්න එකටම කිසිම ඒ කියන්නේ verbal ඒගොල්ලන්ගේ පැත්තෙන් කියන්නේ judge ගේ පැත්තෙන් interpretation එකක් දෙන්නේ නැතුව dictionary interpretation එකක් දෙනවා. ඒ දීලා වෙලා කියනවා මේක හරිද වැරදිද කියන කතන්දරේ. එතකොට parliamentary sovereignty, එහෙම නැත්නම් පාර්ලිමේන්තුවේ ස්වෛරීත්වය, එහෙම නැත්නම් ස්වෛරීත්වයට මේ තීරණ තුලින් බාධාවක් literal rule එක apply කරන එකෙන් බාධාවක් කරන්නේ නැහැ. ඊට අමතරව this rule promotes neutrality of courts. it is also similar to certainty and consistency because it cannot be accessed uh, being biased when it gives effect to the literal meaning of the word. Uh, so judges cannot be biased to the. So sometimes we also can hear sometimes that some people who are having cases, they tell that judge අනිත් පැත්තට ඇද්දනේ අර එහෙම කියලා. එතකොට in the literal when judges are applying literal rule, no one can say something like that because they know the exact meaning of the stuff and they are giving the exact meaning and exact black lettered meaning of the rule, meaning of the word or the term. So no one can question that. So that merit is also there. So when we go for a dismerits, interpretation involves more than giving effect to the literal meaning of the word. So it is court's responsibility to give effect to the laws in a manner which is favorable for the citizen, which is favorable for the who got which is favorable for the people who got affected by the decisions made by decisions or the acts done by some other part. So directly applying the literal meaning does not do that. Sometimes may not do that. So the literal interpretation has that dismerit. And the literal meaning of interpretation prevents a judge from being creative. So as the judges, they have to be innovative and they have to give judgments uh, depending on the case facts. So blindly agreeing and blindly accepting the dictionary meaning does not give the exact outcome to the parties who have affected. So that disparity is there. And the harsh consequences may follow from applying this rule because if no changes are made to legislation, that leads to absurdity or inconvenience. As I mentioned before, in literal rule, they do not care about the absurdity or inconvenience or unreasonableness. So it has that dismerit as well. So the words do have a secondary meaning. Sometimes the words do have a secondary meaning, and the secondary meaning cannot be ascertained without the reference to the concept and purpose in which it is used. So sometimes there are words uh, like, okay, let's take the word animal. So if we take the word animal separately, it gives us it can give different definitions. As I mentioned before, it can be a pet, it can be a domestic animal, it can be a wild animal. But if we read that with the whole context, whole part of the statute, it may express a specific definition. So in the literal rule, they are not directly looking at what that means, and they are looking at the direct meaning of the term, and they are not looking at what are the surrounding factors and what are the other terms in the which are mentioned in statutes. They are not looking at those. So that is also demerit in the literal rule because they are only focusing on the black lettered ambiguous term. So those are the merits and the demerits of the literal rule. So, and I have given two case laws as well. So, am I clear to you up to now? So, is literal rule clear to you?
Yeah, you can unmute yourselves.
Okay, let's move on. I think the silence means that you have understood the stuff. So, second rule. So we stopped at the last demerit. the words do have a secondary meaning. So sometimes, as I mentioned, the word animals have several meanings. So to answer that demerit, the courts have come up with the golden rule. The golden rule states that the literal meaning of a statute will not be given effect if it leads to unreasonable or absurdity. So unlike in literal rule, in golden rule, court is not giving the black lettered meaning of a word or a term if it creates unreasonableness or absurdity. So they are somewhat, so you can see the development here, the literal rule to the golden rule. So now they are focusing on whether they are creating unreasonable or absurdity in the society. So they are not applying such meanings which are creating absurdity or unreasonableness. So golden rule means that when there are two or more meanings to a singular term or word, they are using the word which creates less unreasonableness or absurdity. So the mainly you see this role in Ray Sigbert's case, RESIG WORTH. In Ray Sigbert's case, it's a significant case in the UK history. So in that case, court applied the golden rule. In that case, the son murdered his mother, was not allowed to inherit her estate, preventing him from benefiting from his crime. So in that case, according to the law, the nearest, if a person dies intestate, the properties belonging to that person should go for the nearest living relative of that person according to the UK law. We are talking about movable properties here. So the only living person of this deceased is her son, who murdered the deceased. So you can see the absurdity in this scenario. So he is getting the benefit of the crime, of benefit of committing the murder of his mother, uh, and getting the property of her as well. So court prevented him from benefiting from his crime and applied the golden rule, which created less unreasonable and absurdity. So if they have applied literal rule, they'll definitely go for the go in favor of the son here. So and son will be benefited from his own crime. So now that didn't happen. So because of the golden rule, which is a modification to the literal rule, and the court may depart from the literal meaning to avoid any absurd, unjust, or uh, repugnant outcome. So other than the race equals case, we'll go to the uh, Billion Bay Apparels case. In the Limited versus Billion Bay Apparels Limited versus Chief Minister of Sabaragamu Provincial Council and others. In that case, there was a minor procedural omission. So the place of attestation in the jurat was not in the agreement in between the parties. So the chief minister's party, they mentioned that due to this thing, due to the procedural omission, this contract in between them is invalid. But the court mentioned that the place of attestation in the jurat was not fatal to the proceedings and avoided the unreasonable outcome. So there was a contract in between these parties, and suddenly one party mentioned that the place of attestation in the jurat was not done in the correct procedure, and asked court to make the contract null and void. But court said that that is not a fatal thing and avoided the unreasonable outcome to the party who has affected from that. So other than that, in the Coro Craft versus Pan American Airways case, Lord Denning stated that the literal meaning should not prevail if it produces manifest absurdity. So it is also the same thing what we discussed before. So when you are writing the definition of the literal rule, so definition of the when you are writing the definition of the literal rule, you can refer to the R versus Judge of the City of London case, and the Seafood Courts Estates versus Asher case, and Fianci Soisa versus Fianci Arsakuratna case. And in the Golden Rule, you can go with the Racing Birds case, Billion Bay Apparel Limited versus Chief Minister of Sabaragamu Provincial Council case, and the Coro Craft versus Pan American Airways case. So I'm going to basically give you three cases for each rule. So it is better than giving you 10 to, there are like 10 cases in my notes, but it is better to give you the best three, and it is easy for you to study and go for the exam. So because now we are in a very close range to the exam, so it is better to do so. So moving on, we discussed about the golden rule. So yeah, so this is the second traditional rule that which is different from the literal rule, and you can directly see the development in the literal rule and the golden rule. So after that, after the golden rule, they have developed the mischief rule, which is the court looks to the mischief or the defect in the old law that the new statute was designated to remedy. Or the mischief rule means a rule of statutory interpretation that used to determine the intention of the parliament. So now we are moving to the intention of the parliament. Now we are moving to that when the court is looking in between reading in between the lines written in the statute. So they are focusing on the intention of the parliament. So in the literal rule and the golden rule, they have not. In the literal rule, they didn't. And in the golden rule, they have somewhat developed. And now we are seeing the great development. So in mischief rule, the mischief rule requires a court to suppress the mischief. So they are referring to the issue. So there are three questions to be asked in the mischief rule, which are represented in the Hayden's case. Hayden's case is where the mischief rule was introduced to the legal system. Hayden's case, it is Heyton apostrophe S, Hayden's case. So in that case, the court held that three questions should be asked. Number one, what is the common law before the statute? So before the statute, there are some common laws which are judge-made laws before the enactment of the statutes. So here we are referring what is the law before the statute? What are those common law practices, and what are the judgments given by the judges before the statutes were enacted? So that is the question number one. What is the common law before the statutes? Question number two. Question number two. What is the mischief? What is the mischief the parliament trying to give remedy to? So secondly, they look at the mischief. මොකද්ද මෙතන තියෙන ප්‍රශ්නේ? මොන ප්‍රශ්නෙටද මෙයාලා උත්තර දෙන්න හදන්නේ? පළවෙනි එක තමයි මොකද්ද කොමන් ලෝ එක, ඒ කියන්නේ මොකද්ද මුලින් මේ පනත හදන්න කලින් මොකද්ද තිබ්බ නීතිය කියන එක පළවෙනි එක. දෙවෙනි එක තමයි දැන් මොකද්ද කියන්නේ මොකද්ද මේගොල්ලෝ මේ පනත අරගෙන ඇවිල්ලා මොකද්ද මේකට මේ මොකද්ද විසඳන්න බලාපොරොත්තු වෙන ප්‍රශ්නේ කියන එක. තුන්වෙනි එක තමයි what remedy parliament tries to give. ඒ කියන්නේ මොකද්ද පාර්ලිමේන්තු එක මේකට දෙන්න හදන උත්තරේ කියන එක. එතකොට මේ ප්‍රශ්න තුන යූස් කරලා තමයි මිස්ට්‍රියෆ් රූල් එක ඔස්සේ certificate interpretation එක කරන්නේ. So these requirements are these are the three requirements mentioned in the hearing scales. So in the Dorothy Silva versus Inspector of Police PETA case, Justice Jayapatran applied this mischief rule, where he observed that the aim of the brothel ordinance is to suppress the prostitution and suppress the prostitution. So in the long title, it says that in brothel ordinance, it is this ordinance is there to oppress or to depromote prostitutional activities. So in that case, the Dorothy Silva claimed that he didn't add a brothel there. She just gave away the prostitutes to the people who needed them, and they went somewhere else and let the stuff done in someplace else, and not at the premises of the Dorothy Silva. He just she just sold the girls to the intended buyers. So Justice Jayapathanan applied the mischief rule and looked at the intention of the parliament. Look at what is the mischief parliament tries to give remedy. So he identified that it aims to suppress prostitution, and so if any premises are used to promote such activities and possess all the attributes of the brothel, it will come within the ambit of the ordinance. So just give me a minute. So it means that even though Dorothy Silva claimed as such, the statute itself tries to give the remedy to the issue of prostitution. So as a result of that, even though no prostitution happens in the premises, so Dorothy Silva is still selling the girls to the intended buyers at that premises, it does come into the ambit of the act, because the aim of the act is to suppress the prostitutional activities. So he said that notwithstanding the presumption that criminal statutes need to be interpreted rigidly in form of the accused. So he mentioned that the rigid manner, the literal rule or the golden rule, should not be used in the in interpretation of the criminal statutes, and applied the mischief rule. So further, in the Smith versus Hughes case, which is an important case in the UK jurisdiction. So in that case also, prostitution was involved, and in that case, prostitutes were soliciting. They are looking at they are sneak peeking into the people who are going in the road from the windows and balconies of the brothel houses, and court applied the mischief rule and in that case, because in this case, judge observed that the Street Offences Act of 1959 was intended to clean the streets, as that people will not be harassed or solicited by common prostitutes. So this act itself focuses to stop any interferences or unnecessary harassments uh, to the public who are going in the nearby roads. So they needed to prevent that. The act needed to prevent that. So the act needed to prevent that. So it was the intention of the uh, Street Offences Act. So the judge applied the mischief rule and held that the use of the words in a street and after that explanation, the brothel house owners and the prostitutes, they claimed that they were attracting passers-by from balconies and windows. So they were not in the street and they were not harassing the people who are going on the pavements and in the road. So they mentioning they give an explanation in such manner. But the court interpreted the words in a street that they don't have to literally be in the street, but what the statute tries to answer is to the stop harassment to the people who are going in the street. So in that manner, court held that the use of the word in a street did not prevent their prosecution. So the court prevented them from coming up with that explanation where they were in the that they were in the balconies and the windows and not in the street. So still there was the people got harassed who were passing by near those brothel houses. So court applied the mischief rule. So with that we end the traditional interpretations, some traditional rules of interpretation. So So we can clearly see the development throughout the time from the literal rule to the mischief rule. So we are done with the traditional rules. Is there any question from your side? Yeah, I just saw the messages. Charuka, can you tell me which case you need me to repeat?
On literal rule,
Yeah,
you did. The last case that I wrote was Seafoods versus Usher, but after that
yeah,
you spoke about a case. I just couldn't write down the case name.
yeah. It's Priyani Soisa versus Rienzi Arzakulara.
Priyani Soisa
It's
versus.
Rienzi, Rienzie, Arzakularatna, Arzekulatna.
Thank you so much.
Sure. So, that's it about the traditional theories, traditional rules of interpretation. So we are moving on to the modern rules. So modern rules are the ones mostly used in the civil law countries, and later on with the practice and the global development, they have interacted with the common law countries as well. So now we have a tendency that the modern law, sorry, civil law interpretatory methods or the rules are now using in common law countries as well. So modern rules related to statutory interpretation are purposive rule and the dynamic rule. So mischief rule is the forerunner to the purposive rule. So when I'm doing this personally, Firstly, I did not understand the difference between the mischief rule and the purposive rule. So it is because, as I mentioned even before as well, these rules are interconnected. So literal rule, the golden rule is a development of from the literal rule, and mischief rule is a development from the golden rule. And now we are referring to the purposive rule, which is the development from the mischief rule. So at the first moment, I didn't understand the difference between the paths. So, but there's a slight difference. Even now, you may not identify the exact difference in between. I'll try my best to do that. But there's an extremely slight difference in between that. So because of that connection. So the mischief rule looks into the mischief created by the common law and the remedial measures taken by the act of the parliament. So the purposive rule is certainly a modern version of the mischief rule, as it empowers a court to resolve an ambiguity in a statute by using extrinsic aids. So in the mischief rules, the court tried to get the intention of the parliament through those three questions I have mentioned before. So they looked into the mischief, they looked what is the law before the statute, and they looked what is the remedy. Parliament tries to give remedy. What is the mischief? What is the remedy Parliament intends? So they interpreted the intention of the Parliament through those three questions. But in the purposive rule, they use aids of interpretation. So we are going to do that in a separate session. But in aids of interpretation, they used, I'll briefly tell what is in aids of interpretation. Those are the facts we can use to interpret statutes. So basically, there are two parts. Uh, Internal aids and external aids. Internal aids are the parts we are seeing in the inside the statutes, the long title, short title of the sentence, act, and the marginal notes, interpretation clauses, those stuff. External aids are the dictionary meanings, other statute, interpretation ordinance, uh, and Hansards. We can take them as external aids. So basically, the difference between the mischief rule and the purposive rule is that. So the other rule we are discussing in the modern sector is the dynamic rule, which is a improvement of the golden rule. It enables a court to resolve any absurdity, inconvenience, or inconsistency. It may also allow to fill a gap in the legislation or correct any mistake in appropriate circumstances without offending the doctrine of separation of powers and a parliamentary supremacy. So I mentioned in the before that they see now the constitution and some important statutes such as Human Rights Act of I can't remember the exact year in UK. They see the constitution and the Human Rights Act are the co-acts. So they think that they think these acts are that they assume these acts are living statutes. So they do not give rigid explanations or rigid meanings to the words in those specific core statutes. So let's move on to the purposive rule. In purposive rule, it mentions that the court seeks to advance the general purpose or the spirit of the statute, looking at the overall legislative intent. So, unlike in the mischief rule, purposive rule looks at the overall intent. In the mischief rule, they only focus on the mischief and what the specific part of the statute tries to give what is the remedy the parliament tries to give through that specific part of the statute. But in the purposive rule, The court seeks to advance the general purpose or the spirit of the statute, looking at the overall legislative intent. So this overall legislative intent means not only the aids we are finding inside the statute, but also what we are finding outside the statute. As I have mentioned, which are the external aids. Hansards, yeah, when we refer to the Hansards, uh, at the time where that specific statute was passed, you have directly identified the intention of the parliament. So there are some key cases in this rule as well. Firstly, I would like to mention the Pepper versus Hart case. In that case, the court firstly allowed reference to Hansard's parliamentary debates to discern Parliament's purpose where legislation is ambiguous. So before that, the external aid Hansards were not used to interpret the intention of the to get the intention of the parliament, but through this case they allowed Hansards to take to get the intention of the parliament. So whenever the legislation is ambiguous, they go through the Hansards and get uh, the ambiguous terms to be sorted according to the intention of the parliament. So purposive rule is that, and other than the Pepper versus Hart case, I would like to uh, mention the Shriyani Silla versus Iddamalgoda case. Yeah, in Shriyani Silla versus Iddamalgoda case, Justice Bandara Nayaka dispensed with the literal rule in favor of the purposive rule. So Somati versus Veerasinghe case, what we have discussed in the literal rule, and the Shriyani Silla versus Iddamalgoda case is connected. So through the Shriyani Silla versus Iddamalgoda case, the judgment given the precedent created by the Somati versus Veerasinghe case was demolished, and they applied the purposive rule in this case. So in order to facilitate the use of fundamental rights action under Article 126 subsection 2, but we referred to the Somati versus Wilson case as well. Uh, in this case also, the wife of the person imprisoned was filed a FR application in front of the Supreme Court. But unlike in the Somati versus Wilson case, uh, court allowed this application on behalf of her husband by adapting a purposive rule of interpretation. In the case of Somati versus Veerasinghe, the court ruled that the wife could not, deceased person's wife could not file a plaint under fundamental rights provision. However, in the aforementioned case of Riyani Shilla versus Iddamalgoda, the court overruled the previous decision and held that the deceased wife did have the right to file a plaint under fundamental right provisions, especially in cases where her rights to property and equality were being violated. So uh, you can now see the difference. So in the literal rule, they applied the direct what is mentioned in the statute, but here they have moved on. Now they are looking at the humanitarian side of the issue. So if that person is deceased, the person who was in the capture or the person whose rights have been violated has deceased. So now there's a practical issue whether he can come to the Supreme Court even through attorney law, because he is no longer a living person. So in such a scenario, court identified that and came up with the the practical issue of the Somati versus Virasinghe case and answered that issue through the purposive rule. So they applied and the practical scenario and came up with this explanation. So Pepper versus Hart case I have mentioned, and in the Vikramasinghe versus Hettiarachchi case, this is not an extremely important case, but keep that in mind. In this case, court looked even into the social purpose of the statute. So now you can see the length they have gone. So they are looking into the social purpose aspect. So at the very beginning, they just looked at the black letter meanings of the statute, but now they are looking at the social purpose of it as well. So you can clearly see the development in that as in the rules through these. So those two cases, and let me give you and the R versus Secretary of State for Environment, Transport and Regions and others. So in that case, intention of the Parliament can be taken through whatever source that objectively accessed can be used. So basically intention of the Parliament through whatever source that can be objectively accessed can be used. So it is a broad argument given in that you should remember that case because it says that court can use whatever the source available to them to get the intention to claim out the intention of the Parliament. So that is what is mentioned in the purposive rule. So we are now moving on to the final session. So final modern rule of modern rule of interpretation, which is dynamic rule. Dynamic rule is not very much important when you are going for the exam, but personally, I did not study that for the examination, but it is better to keep that in your mind. So in dynamic rule, it is applied to resolve statutory ambiguities and absurdities associated with the Constitution, human rights legislation, and legislation giving effect to treaties. As I mentioned before also, dynamic rule is used in only in these sort of statutes. The Constitution, human rights legislation, and legislation giving effect to the treaties. Because through the dynamic rule, they assume that these legislations are living documents. So they are treating these documents in a less rigid manner. So unlike giving a rigid interpretations to the other statutes, they are giving a tender interpretations to these statutes because as you know, our constitution was enacted in 1978. After that, nearly we are coming close to 50 years. Several changes were done, but no initial changes were made to the constitution of Sri Lanka. So as you can clearly see, the situation in the 1978 is extremely different from the situation we are having right now. So we are trying to answer questions through a constitution that we have enacted nearly 50 years before. So if we have not given the freedom to grow for the constitution, or if we have not, if we have rigidly interpret the sections of articles of the constitution, it will be an issue because rigid constitution shall restrain the the power of it, because it should have that freedom to move on. The constitution should have the freedom to be applicable even in the future. So to give that feature, the courts are applying the dynamic rule, which identifies the constitution and human rights applications, and they interpret these statutes in a very tender manner. So that is what is mentioned in the dynamic rule. So in basically there are some cases, and I would like to mention only one case. Yeah, basically you can take the Sri Silva versus Siddhamalkota case as well, because in that case purposive rule and dynamic rule both used. So other than that, you can go with the Hunter et al. ETAL versus Southern INC case. In that case, Dickinson, the judge, exposed the following: the task of expanding constitution is crucially different from that of constructing a statute. So basically, that is what I mentioned before. A statute defines present rights and obligations. It is easily enacted and easily repeated. So we are referring, the acts can be easily enacted and easily repeated. If there's an issue, we can get made an amendment to the such as with the votes of the parliament. Even if it is a really concernable act, we have to go for the 2/3 majority. Otherwise, we can go with the simple majority. So it is significantly easy. But a constitution, by contrast, is drafted with an eye to the future. It must therefore be capable of growth, of development over time to meet new social, political, and historical realities, often unimagined by its frame. So I don't think in 1978 they may not have think that even about cyber crimes. So now we are having cyber crimes today. So at that stage they may not have seen that. So if court rigidly interprets such an important statute, such an important constitution, it will affect badly in the future. For stop that, to prevent that, it is better to interpret those kind of statutes in a less rigid manner. So that is what mentioned in the dynamic rule. So today we have, it took more time that I have allocated, I guess, but fortunately we have completed all the 5 theories of the statutory interpretation. So we have discussed literal rule, golden rule, and the mischief rule, which are the traditional rules of the statutory interpretation. And we also discussed the modern rules, which are the purposive rule and the dynamic rule. When you are going for the exam, yeah, I'll give you a question before summing up the session. So I'm referring to the October examination of 2024. That is the previous year. So in that question paper, question number 7, the Employment Rights Act states employees shall be entitled to annual leave at least 14 days. An employee has been working part-time for several years, and the employer has been provided 7 days of annual leave each year. Discuss how the court might interpret the entitlement to annual leave under this statute, considering rules of statutory interpretation. So, when you are writing answer for this sort of an question, firstly you have to give a brief definition about what is statutory interpretation and what are the ambiguous terms which are included in this part. So I identified the but employees have an ambiguity uh, because it doesn't say that it applies to part-time only to full-time employees or part-time. There's no such explanation in that part. So I have my answer was made basically made out of that argument. So like that, you have to identify the issues or any ambiguous terms or words in the statutes that they have referred in the question. So after that, you have to tell these rules of interpretation are available, and you have to go through that. So you have to describe literal rule and how literal rule should be applied to this scenario with the case references. So after referring to all four, we are not using dynamic rule for this because dynamic rule is, as I mentioned, it is only applied to significant acts and the constitution. So therefore, rules should be applied. And after that, you should tell in the conclusion. I think you know about the IRAC method. So according to IRAC method, in the conclusion, you should mention that even though these rules are available, uh, purposive rule, purposive rule or the literal rule or the whatever the significant or whatever the most promising rule, which should be applied, should be used due to these reasons. Okay, so as I mentioned in this question, there's an issue with the term employees. So whether it includes part-time employees or not. So that question should be answered according to the theories of interpretation. And I would like to mention that you are not getting marks for the cases you have written or the facts you have identified or the definitions you have given. It is all about your argument. If you have a good argument, even if it is at the first glance, it can be seen as a stupid argument by the examiner. But if you have done uh, a significant or a commendable argument for that stupid fact, literally stupid fact, you can still get the marks because of your argument. If your argument is good, you will definitely get good marks. So, and as I think these stuff are mentioned to you, always go through the past papers because most of the times they are using same method. So, uh, so that is about the today's session. So we have done the three traditional rules and the two modern rules. So is there any issue from your side?
Are there any questions? Alright. I think we have come to the end of today's session. If there are no any questions, we will conclude here. On behalf of Pro Studies, I would like to express our heartfelt gratitude to Mr. Sanka Ranawake for sharing such valuable knowledge and practical advice with us today. Your guidance will definitely help students approach the exam with a more confidence and clarity. And to all participants, thank you so much for joining us and being part of this session. We hope to see you in our upcoming sessions in the following weeks, which are specially designed to support your April examinations. Until then, stay focused, keep studying, and give your best. Thank you once again, and have a great day, everyone.